You record. Okay, so we're in criminal justice, criminal law and procedure, and we are moving ahead. So let me go ahead. Oh, where'd that go? Hold on, I'll get there. I just want to show you what I've got going on. There we go. Okay, so I just want to show you, I've made some updates to the module because, you know, this back section of the class is completely new, right? We were going to have a mock trial, and with the amount of time we had, I just couldn't figure out how we would do that.
Frost those cookies.
So any rate, so we've kind of, you know, changed things up. So chapter 11, now you can see it's available. I have the slides I will be using, and I'll, chat, whatever that is, at any rate. So these are my slides, and I'll probably be making a few changes. I also have the publisher slides because I know a lot of you enjoy, you know, I think they're way too much content, but they're very useful. So I do have the publisher slides linked for you. And then the new assignment that I want you guys to be aware of is the chapter 11 quiz. Okay, so just normal old quiz. You can take it as many times as you like between now and the final exam. Okay, so that is up, so you can get crack-a-lackin' on that. And then I've just put a few little links, some things, some websites that are kind of fun, you know, how to do your opening statement. I don't know, just kind of interesting. We may bring in an assignment for like an opening statement. So let me see. But anyway, so those are some fun little web links you can check out because, you know, maybe you're sitting around wondering what else to add. Okay, so then let me.
Esther, what's the trial notebook?
Oh, yeah. So that was, I need to just delete that. That was if we were going to do our mock trial. So, which we're not. And I'm leaving, we may come back and do some sort of opening statement, but let me remove that. I know I was looking at it earlier and then I didn't remove it. But yeah, so we're not going to be doing the trial notebook or anything. Let me delete that. That was when we do like the full, you know, mock trial. So we put together like all these documents and all kinds of things. So yeah, so that's not happening. Not happening. And who knows, maybe we'll come back and watch, because I figured out, you know, now that I know how we can like watch a documentary together, we might watch one of the Making a Murderers. So I don't know if anyone has watched that series on Netflix, but yeah, some of you would be awesome. So Making a Murderer is another great documentary on Netflix, and we may like watch one of those together. And let's see who else have joined us. Hi, Jonah, good to see you. So let me go ahead and let me share the slides and let's jump in to chapter 11. And I hope you guys are still taking the opportunity to read through the book. I know that's not exciting, but it is, you know, useful because there's stuff that I'm not highlighting that is highlighted in the book. So that's always good. Okay, and we are recording. As always, you guys, you are free to unmute yourself and ask any question or chat in any question, and I'll, you know, read it and go over it with everybody. So if you don't want to talk, you know, that was another discussion we were having is, you know, with the cameras and everything. But yeah, you're not required to show yourself, although it is fun to see people. But you can always just chat in your question if you don't want to speak or anything, okay? I'm loving my background. Okay, so I've put this up, and this is a lot of words. This kind of violates my, you know, there's too many words for PowerPoint, but I wanted you just to see that basic rundown of a trial. Okay, so you've gotten through all the pretrial motions, you've gotten through selecting a jury, motions in limine, all of that, right? And so now you are at the beginning of the trial. You're ready to start the trial, you know, so, and maybe I'll find a couple good videos, but you know, the bailiff calls it to order, you know, everyone all rise, they all stand up, the judge walks in, takes the bench, you know, everyone is seated. And then, you know, sometimes the judge will, you know, have a couple statements or just, are you guys ready to proceed? And so what happens next? What is the real trial? So here's your basic list of what is included in the trial. So you start with opening statements. Prosecution goes first. Defense then does their opening statement, and I'll come back to that in a second. Then you move into what is called the case in chief of the prosecution. And this is where they present their case. They present their evidence. And it begins with the direct examination of the prosecution witnesses, and then you get the cross-examination of the witnesses. And please notice it goes witness by witness. So like if John takes the stand as a prosecution witness, he is directly examined, and then he is cross-examined by the defense. Then he's done. Then if Sally takes the stand as a prosecution witness, she is direct examined, and then she is cross-examined. So when I say it goes witness by witness, the direct and cross goes, you know, as little pairs, right? You know, if Jesus is called as a witness, he testifies, direct examination, and then he's crossed, right? So it's a little pair, okay? So you do direct examination, the defense does their cross-examination, witness by witness, and then you also have the possibility of what's known as redirects and recrosses. So redirect, you go, right? Let me think about this. You do direct examination, then the other side would do cross, and if they want, the prosecution could do a redirect, and that also opens up the possibility of the defense doing a recross. At some point it would be, you know, the judge would, because it's, you know, you can't let it get too out of control, but just know that is something that is pretty typical, that have a redirect or a recross. I don't know, do you really have recrosses that much? Phone a friend? Hun? Are recrosses very common? So I just asked my phone a friend. Every time there's a direct, you have to offer them to have the chance to do a cross. So you'd have to end at the recross if they want to, but sometimes they will not take that opportunity. So at any rate, and then at the end of the prosecution has called all their witnesses, the prosecution arrests what is known as their case in chief. So sometimes you'll kind of see that dramatic moment, the prosecution arrests their case. So that means they have presented all the evidence, all the witnesses they feel they need to prove their case. And remember, go way back. What are we trying to do here? We have crimes that this person has been charged with. Those crimes have elements, you know, 2 elements, 3 elements, 4 elements. You know, maybe we'll come back to homicide. I know that was something you guys wanted to look at. You know, the unlawful killing of a human with malice aforethought. So unlawful killing of a human, malice aforethought, really 2 elements, but you know, so you have to prove each of those elements. So the prosecution in their opening statement, you know, will go over that, and then they'll present all the evidence they feel they need to prove those elements beyond a reasonable doubt, okay, to that jury. So when they feel they've done that, they will rest their case. And then the defense begins their case in chief. So it starts similarly. They have their witnesses they call, and they do their direct examinations. And then, right, the prosecution is offered a chance to do the cross-examination of each witness in a pair. When all of that is finished, the defense rests their case in chief. And then we move into closing arguments. The prosecution begins their closing argument first. And then when they are done, the defense does their closing argument. So again, if you guys have any questions, feel free to chat them in. I wanted to make a quick statement about, the defense opening statement. Something kind of interesting. Defense doesn't necessarily have to do their opening statement right here. Why does it keep doing that? They don't have to do it necessarily at the beginning of the entire case. They could, if you take your little mouse, they could actually bump their opening statement down to when they begin the presentation of their evidence. So that can be kind of a tactic, depending, it's you know, it may not be what the jury is expecting, because they're expecting to hear from both. You may not want to do that because you don't want the jury to only have heard the prosecution's story the whole time. You know, when do you tell your story? If they have to wait several days, you know, will that influence them from persuasion theory? So it's a tactic, but there are times where the defense will say, you know, we're going to waive our time. I mean, we'll reserve our right to present our opening statement at the opening of our case in chief. And so they'll hold that. It could be because they don't think the prosecution's going to meet their burden of proof. that they don't think the prosecution will have enough evidence. And so maybe they're going to move to close the case earlier. You never know. But so that is something that you will see periodically. It is allowed. It's a strategy, a tactic. So it's really kind of up to the individual case and the theory, the needs. But I wanted to give you guys just kind of this basic timeline of what you see and how the case flows. Okay. Questions or comments so far? And then we're going to kind of dig into each of these pieces in a little more detail. And of course, your book does as well. And you'll definitely want to have your book, you know, to help you do the quizzes. Okay. Questions, comments, issues? Just making sure. Mark, I don't know. Oh, people do want to see prom pictures. Yeah. That could be our next theme. All right, so I'm going to keep going. Okay, so, you know, who presents their case first? You probably know that obviously it's the prosecution presents their case first. And it's not just a coin flip, you know, how did that happen? There is a lot of theory there. So the idea is that the prosecution has the burden of proof. You know, when you come into trial in the criminal system, you are innocent until proven guilty. Mark, that is amazing. You're innocent until proven guilty. So that means that the prosecution has to advance, right? You know, advance the ball, so to speak. They have to meet that burden to then, you know, prove that you are guilty. And that burden, as you guys know from our first half of the semester in the midterm, right? Beyond a reasonable doubt, the highest evidentiary standard we have. So they have to meet that burden. And the defense actually doesn't have any burden of proof. So there's a really deep in the weeds, interesting concept there that when you go into a criminal setting, the defense does not have a burden of proof. Sometimes people like, what do you mean? But they want to disprove what the prosecution's saying. Well, sure they do. But legally, and from like a very deep place, you come in innocent unless they have met that burden, unless they can advance the ball forward. Otherwise, you should be found not guilty. So the defense does not have anything to prove. And they could simply, one of their arguments, and this does happen in cases, they might not even say one word about anything the prosecution has said, except to argue that you haven't proven it enough. You know, you've just gotten to here. You didn't get up to here. Like, you haven't proven it enough. I don't have to say a word. You don't have enough evidence to move forward. You know, I don't even have to come up with a story, you know. So that is something that you will see sometimes if you watch a lot of cases very closely. But because the prosecution has the burden of proof and they are the ones that have to advance the ball, then they go first to present their evidence. And it makes sense on multiple levels, right? They're trying to go first, but also if they can't meet their burden of proof, then there's no reason for the defense to say a word. There's no reason for the defense to take the stand. So it's sort of, you know, from multiple levels. But I don't know. So my question to you, and you guys can chat or unmute yourselves, and I'm going to stop the share so we can kind of see, is, do you think it matters? You know, from your perspective, does it matter? Would it matter? And I know we've got a few more people joining us. Hi, Esmeralda. Good to see everyone. So yeah, do you think it matters who goes first? And maybe you guys, Aaron just says, it is what it is. You know, I mean, it must matter or else it wouldn't be the rule, right? But yeah, what do you guys think? Melina says it matters. Oops. Do you want to give us a little more or any thoughts? Okay, I like that. Diana says they need to know what they're defending themselves against. I think that's another great way to think of it. You know, what's the purpose of the defense even doing anything, right? You know, I don't exactly know. I mean, maybe this big witness that I think is going to be so amazing, maybe they fall apart, you know? And so if they fall apart, then I don't need to worry much. Khaled says it matters. I don't know, any other thoughts on that, on, letting the prosecution go first? Are you okay with it? Did you ever wonder, like, is that something that used to bug you, or does it make sense now? Like, are you asleep? No, I'm just kidding. I'm just kidding. And I thought about doing the Quizlet again. And literally I was like, no, we cannot get trapped in Quizland. But
maybe, I don't know, can I say something?
Yeah, no, do please.
Maybe for the jurors, you'll get like the first impression, putting your case first and like putting your, your seat, because it's all about gaining like credibility, right? So just like putting your case first, and then somebody has to like point you wrong, right? So I guess it's just having the first word, I think, matters.
Yeah, that's a great way to think about it. And there's a persuasion theory, if you guys have ever taken like your communication classes, or taken debate class or anything, called inoculation. So it's kind of like a little vaccine, is the theory behind it. And that is that if you can get the first word, you can kind of prepare them for what they're going to hear. And they might be more receptive to your message because they kind of heard it like a week ago, or they kind of heard it a couple days ago. So it's just theory of inoculation. You kind of give them a little dose of your theory, and then later it'll make more sense. But I like it. Ron says it matters, because they need to know what they're getting themselves into. I'm assuming you're meaning the defense on that one, but if not, maybe explain for us. But yeah, this is so great. I think, again, when you say to yourself, it's a system designed in many ways to protect the rights of the defendant, of the accused, it certainly makes a lot of sense from that place, because that way, like kind of Ron is saying, the defense knows what they're facing, knows what, and also not just like on paper what they're facing, but they know how it played out in real time. You could tell me on paper you have a great witness, but in real life, they might have fallen apart in front of the jury. So I think that's a really great one. But then it also lets the prosecution like set the stage, as well, which is interesting. So I think those are all like really good comments. Thanks, guys. I don't know if you guys have any other thoughts on that one. And our numbers are just going up, you guys. So I love seeing all of you joining in. Yay. But yeah, I was scared to try Quizlet again. So maybe Wednesday I'm going to play with it, but I was scared. Anyone remember that? And I told some friends and family, I'm like, we got trapped in a game. It was amazing. So it was like Tron and Jumanji all spun up together. Okay. So then what I have here, I just have a few little links, and I don't know, let me see here. Which ones we should watch. And I'm going to stop the recording because I think if I play these, it'll be a thing. But just know, when you go back to the slides, you can go ahead and like watch these. I mean, they're just a few minutes long, but you can kind of enjoy the fun of that one. So let me see here. So there's a few video clips you can go back and watch. They're linked in the slides. So opening statements, and then we move into direct examination. So what is direct examination? This is, kind of the basic introduction, right? It's when a witness is questioned by the side that called them to testify. Okay. So sometimes people think of it as like a friendly witness. The people that want you to testify are going to be questioning you. So they have called you to be a witness. So often, yeah, it's more friendly. It's, we may not see it as super adversarial. The types of questions on direct examination are open-ended, okay? And in fact, they have to be somewhat open-ended. So you're not allowed to ask leading questions, and we'll get to that one in a second. But so open-ended, what were you doing that day? What, if anything, happened next? What did you see? What did, kind of the who, what, where, why, and how type of questions. What did you see? How did you feel? What were you thinking? What did you do next? Those are often, the basic questions. A really good direct examination should let the witness be the star. A good direct should let the witness literally tell their story to the jury. So our legal system doesn't allow for someone just to tell their story, you know, in a narrative. It has to be through the question and answer prompting. But good direct examiners have a ability, a good style to ask a question and let the witness give their answer and ask. But the star and the focus is on the witness, not the attorney. So sometimes a really good direct like won't seem that special because they're just like in the flow, and it's a lot of, well, what happened next? What did you do when you came upon the car accident? What did you see next? Did you notice anything unusual? You mentioned that there was a pencil on the ground. Did you do anything? And they're like, well, yeah, I did this, I did that. So they're responding to the questions, but the focus is really letting the jury hear this witness that you have called. And through open-ended questions, you know, who, what, where, when, why, how, type of questions. And obviously it's your own witness, so you can prepare ahead of time. We'll get more probably into some of this. I'm thinking what we should do Thursday, but you'll have a plan. You'll have maybe even questions, you know, written out. You'll have an outline that you'll follow, very specific information. I want this witness to give me the things I need to prove element 2. And I want this witness to give me the things I need to prove element 3. You know, so you'll know exactly what you want to get from each witness, and should have a plan or an outline or something to get that. But you want to let the witness tell their story. And I think, so we might watch one of these little videos, and I'm going to pause the recording here, but when you go back, you can watch these. They're embedded in the slide. So I think this is a really great video, and you can watch it. It's embedded in the slides to help you understand which, what I was saying when I wasn't recording, and that is that the hallmark of trial court is the presentation of evidence through witnesses. So important. And let's see here. Let's see, Melina has a comment. I read a case where a guy was caught in the pool of an apartment, not swimming. Okay. And his tenancy was terminated for violation. So burden of proof was on the landlord. Yes, so whether it's a civil case or a criminal, because even in civil, the burden of proof rests with the prosecution or the plaintiff. So it's the burden of proof is on the plaintiff to show that. The only time we see a shift is when, and since this is criminal law, like if a defendant raises self-defense as an affirmative defense to a crime, then the self-defense elements are on the burden of proof shifts to the defendant to prove self-defense. And then the prosecution would have the chance to knock that down. But yeah, we all just want to go swimming in our apartments right now. But yeah, so cool. So you might enjoy, I don't know if there's any other comments or questions so far. Is this coming together for you guys a little bit? And I really recommend going back and watching some of the longer clips that I've embedded for you. Just giving you guys a second to chat in, and I'm just admiring my background again. Balloons are legit. Okay, what do I have next? We're not gonna watch this one right now, but I thought this is kind of fun because you're gonna get to see some super high level college students doing mock trial. So this is a mock trial competition. And they're presenting, you know, their direct examination. So understand that both the students are on both sides. So when it's a witness, that's like a student, you know, sometimes Mark, you know, they bring in an acting student who's really good at being an actor. So you guys can watch that. That's kind of fun to see. Okay, so cross-examination, and I don't think I have any good clips yet for this, so we'll get them in. But at any rate, so cross-examination. This is the other side questioning the witness, really to challenge their testimony, maybe to poke holes in it is like a phrase you hear, you know, kind of to show where the problems are, maybe to show where the bias is. And bias, you know, it could be as simple as you're best friends with this person, aren't you? This is your son, this is your mom. Like, you know, I don't need to go super down the rabbit hole, but this is your best friend, you know, done and done, you know. So we'll probably go into some more specific tactics for cross and direct on Thursday. But at any rate, and I know we've got some experienced mock trial people. I know for sure Samantha and Tanya are some experienced mock trial people. So I don't know if we have anyone else. Maybe that would be fun. If you have done mock trial, will you chat in? Okay, so Mark, I think has done mock trial. So I've got Mark, Samantha, Tanya. Will you guys chat at me? Yeah, if you did it in high school, I think in our area, that's probably the only time. There's not many colleges that do it, but I mean, there's some, but will you chat in at me? Because maybe I'm going to reach out to you guys to do something fun. I don't know. So chat in if you've done mock trial in high school or whenever, just as a family, you just do mock trial. Anyway, so cross-examination. And this is also why sometimes people say it's hostile, you know, it's adversarial. This is not the witness you called. This is someone you disagree with. This is someone that you don't think is telling the correct version of the story. And so part of your role is to expose their bias, you know, chip away at their testimony, show the problems with it. And the real thing here that you see is the leading questions, the famous leading questions. So these are closed-ended, you know, sort of binary questions that tend to have a yes or no, you could see, and kind of leading. So there's lots of like fun, exciting examples of these, you know, the famous question of like, when did you stop beating your wife? Like there's what, you know, or, you know, isn't it true that XYZ? Isn't it true you were drunk that night? You know, isn't it true that you hated your neighbor? Isn't it true that you stole money? You know, so part of it is that you as the attorney are almost making yourself the star of cross-examination. So on direct, you really want your witness to be the star. On cross, you will often see the attorneys be the focus, you know, and they get really close to that idea of what we would call testifying. So I'm going to ask you a question, but I'm kind of planting the seed in the jury's mind. Isn't it true that you hated your boss at work? They're like, yes. Oh, cute.
I used the piping bag.
So, you know, isn't it true that you hate your boss? I need like one of those like split screen things. Yes. Isn't it true that you felt your boss cheated you out of your bonus? Yes. Isn't it true that you had posted on Facebook that you wanted to hurt your boss? Yes. Isn't it true that you're a horrible person? You can't ask that one, but do you see how like the attorney is really setting the stage, and they're getting all of that stuff right out. And so even, you know, even if they say no, it gets a little problematic. So I'm going to bring in some cool footage of that one, some cool stuff. But do you guys have any, do you want to either chat in or unmute yourself and share a leading question? So you can either chat it in and I will dramatically perform it for the group. Or you can, and let's see who else. I see Richard, I see Jennifer. Just trying to make sure I say hi to everyone. So good to see you guys. And if you know of anyone that's having troubles, have them shoot me an email or let me know if you need anything. But anyway, can you guys think of can you either chat in an example of a leading question? And a leading question, I didn't even give this to you guys. A leading question is a cue where the answer is suggested in the actual question. There we go. There's a definition. It's like I've taught this before. Yeah, I'm just like my brain scrambled. So a leading question, what is it? It's a question where the answer is suggested in the actual text, in the actual question itself, you know, so isn't it true that you hate your boss? Well, the answer is, yeah, I hate my boss, you know, so that the answer is already there, as opposed to how do you feel about your boss? So how do you feel about your boss is open-ended. Isn't it true that you hate your boss? I'm dying. We're going down a rabbit hole. Oh, Mark's giving us the spicy. Oh, geez. You know, isn't it true that you saw, you know, XYZ, you know. And so I may put up an assignment on Thursday, which will be kind of fun. Like take a thing and write it as a direct and write it as a leading question, right? You know, something like, how were you feeling on Monday? Open-ended. Versus, isn't it true that you woke up in a terrible mood on Monday? What do you have to drink when you're teaching class? Diet Coke in my fake Yeti cup from Target called a Zach, versus, isn't it true that you have a Diet Coke when you teach class? So do you see the difference there? It's subtle, but one is open-ended, because maybe I'm going to say, oh, actually, I have water. Actually, I have an energy juice. Actually, I have milk. I have, sometimes I have LaCroix, my new favorite, oh my gosh, watermelon LaCroix. LaCroix, I don't know. Anywho, but yeah, so isn't this a picture of you stealing money from the cash register? That is awesome, because they're like, yes, So that's how you want to think about it. Like, what were you doing on December 20th at 10 o'clock at night? What were you doing? Open-ended. Versus, isn't it true that on December 20th at 10 o'clock at night, you were robbing the bank? Okay, so there's kind of your basic, rundown of cross leading versus an open-ended question. Let's see here. Mark, isn't this a picture of you stuffing your face on the one free sample per person? Oh my gosh. Have any of you guys been to Costco since the new rules? I guess, yeah, they don't have samples anymore. So yeah. And I'd said for a while that if Costco got rid of the samples, it would make everything go quicker, because the only thing that really holds up the traffic is the samples, right? That's where everyone congregates and you can't get around them. Or if they did like a whole sample bar somewhere else in the store, because and I think, although I haven't been, but I've heard that having the samples gone is moving things a lot better. Because think about it, that would be the total bottlenecks were around the samples. Oh my gosh. Any rate, other thoughts or questions? Because I think we're pretty much at our ending point. So what should you be working on right now? You should read the textbook, because it's a good chapter. Okay. Look at the slides and I have the textbook slides if you'd prefer to look at that. And then maybe watch a couple of those little embedded links in my slides. And I also added some links about opening statements and closing statements, like some tips. So you can look at those couple links just for fun. And then the quiz, you could start taking the quiz, okay? And so we'll still be in this chapter on Thursday, and we'll kind of be finishing up. So are there any questions on the material so far, or comments? I'll give you guys a minute or so, because then I'm going to stop recording and see if you guys need anything. You're killing me, Mark. I'm still scared. Like, what is this thing? Hold on a second. Let me finish the recording and then we'll see. And another thing, if for some reason you didn't submit your Pick My Jury assignment, will you please submit it? Because that's how I'm grading, is by who submitted. So get it submitted. If you didn't, I think most of you did. But just make sure, or shoot me a message if it was one of the ones where like you presented it but you didn't submit it. I don't know. Just get it submitted, because I'll remember. But anywho, other questions on the material? We're just missing those Costco samples. Oh my word. Okay, you guys are killing me. Okay, so I'm gonna stop recording.